Hello, welcome to Immigration and You. My name is Alan Kay. I have over 35 years experience in immigration, naturalization, visa, and consular law. And let me introduce my colleague.
I'm Michael Piston, and I've been practicing immigration law for over 25 years.
On today's Immigration and You program, we're going to discuss fiancé visas. Fiancé visa is a non-immigrant visa, which is called a K visa. We have an American citizen who files papers with USCIS, U.S. Citizenship and Immigration Services, and he says, I'm an American, I'm engaged to this man or this woman, and I want to bring my fiancé here, and we're going to get married here, and I want her or him to get a green card. So the American citizen files a fiancé petition with USCIS, includes proof that the person who's filing, you've got to be an American citizen. So green card holders don't file fiancé visas. The petitioner, the person who's filing, has to be a U.S. citizen. He has to either never be married, or if he's been married before, he has to be divorced. The person he's bringing here as fiancé, or she is bringing as fiancé, has to be never married or divorced. Those papers are put in with a package that goes to USCIS. If the petition is approved, it's sent to the American consulate overseas, and the fiancé goes into the consulate for an interview. If the consulate feels that this is a legitimate bona fide application, at the end of the interview, the fiancé will get a fiancé K-1 visa and come to the United States to be admitted as a fiancé for 90 days. They have 90 days to decide if they want to get married or not. And if they do get married within 90 days, another application is filed to change the fiancé visa person who's on a K-1 to a green card. And that could take maybe another 6 months. So that's basically the process. But Michael, why would somebody go into the American consulate for an interview in connection with the K visa and not get the visa? What could happen at the consulate?
For example, the consulate might determine that they hadn't met within the last 2 years, which is one of the requirements of a K-1 visa. But far more common is the problem of establishing a good faith relationship. And this can be particularly difficult for people who, by definition, have not lived together as man and wife. Since one of them is obviously in a different country than the other, they probably haven't lived together at all. There's often very little that they can provide in terms of documentation. As a consequence, some consulates have become notorious for refusing fiancé visas on the grounds that a good faith relationship has not been established. Ho Chi Minh City, for example, has become a very notorious consulate for this area.
So basically, if a person gets denied the fiancé visa, either you or I or the lawyer either comes back to the consulate and tries to persuade them that that denial and not issuing the visa was a mistake and this is a real relationship and they should issue the visa. Or I guess number two, you might have to file the fiancé visa petition over again because it times out after a while. Or number three, in some of my cases I've suggested, or the clients have suggested, just get married and we'll do a green card marriage case. What have you done in some of your cases where they went for an interview and the visa was initially not issued? Where did you go from there?
Well, it depends. Obviously, if you could try to resolve the matter at the consular level, often that's not possible. Sometimes the best way of dealing with it is just let the consulate send a letter to the CIS recommending that the petition be revoked. The CIS will then issue what is called a notice of intent to revoke. You have 30 days to respond with evidence showing that in fact there is a good faith relationship. The CIS is much more reasonable about this than the consulates are, and very often with competent representation you can get the CIS to reaffirm the K visa petition, and then hopefully the consulate will issue the visa.
But I found that in practice, when the fiancé visa petition is sent back to the service center, the service center doesn't issue a notice of intention to revoke, and they just say, well, it's timed out. You know, the fiancé visa petition was good for so many months and it's dead, and you just don't hear anything at all from the service center, and therefore I would go on and either refile another fiancé visa petition with a lot more documentation, or maybe the clients would decide the hell with it, we'll just go get married and do an immigrant visa case. What do you think of that?
Sure, those are options too.
All right, so now the fiance comes here and they get married, and then an application is filed to change to permanent resident. There's an interview. If the interview goes well, the person becomes a conditional permanent resident, meaning gets a 2-year green card. At the end of 2 years, you have to file again to change the temporary green card to a permanent green card. Now, if they're still married and living together and everything is fine, then it shouldn't be a problem in getting the temporary card 2 years later changed to a permanent card. But what happens if there are problems? What kind of problems might they face where the husband and wife are not going to file together? Something goes wrong and it becomes a problem case. What could go wrong?
What can go wrong in any marriage, Alan?
Right?
I mean, the immigrants face the same problems in marital relationships that Americans do. And of course, in the United States, it's been estimated that 50% of marriages end in divorce. So there's really no reason to expect that immigrant marriages are going to be any more viable.
So you're saying, let's say the husband who's an American citizen, I'm not signing this paper to help you change your temporary card to a permanent card. I'm just not going to do it. What do you tell the fiance on the K-1 visa who has a temporary green card which is expiring?
You want to know the truth?
Yes.
I tell them the divorce is ass.
Okay.
And there's a legal reason why, oddly enough, the CIS encourages people to get divorced. Because if you're in that type of situation where you're married to a U.S. citizen and he will not sign what is called the Form I-751 to have the conditions of your residence removed, you're actually better off from a legal point of view if you're divorced from him than if you're still married to him and try to pursue the matter on your own. Either way, you have to apply for what is called a waiver. But if you're married to your husband, your petitioner, the only way you can file a hardship waiver showing that you or your children would suffer extreme hardship if you were removed, or you can file a battered spouse waiver showing that you have been battered by your spouse. But if you're divorced from your petitioner, then you can file either of these petitions, or you can file a petition simply stating that I married this person in good faith and now we've gotten divorced, please lift my conditions of status. So it's actually, from a legal point of view, better to get divorced if your petitioner will not sign the papers to have your conditional status lifted.
Okay,
So
well,
thank you, CIS, for breaking up marriages.
we're running out of time. We will talk more in the future about K-1 and fiancé visas and conditional residence. This is the immigration program, Immigration and You. My name is Alan Kay, and your name is?
Michael Piston.
For more information, contact us at the number and address scrolled below, and we'll be happy to continue our discussion with you on the phone in the office, and we'll be back soon with Immigration and You. Thank you.